Any discussion? All in favor, aye?
Aye.
All opposed, same sign. It's all right, unless you have specific questions from the staff. I've asked for written reports. Are there any specific questions you'd like to ask from any of the staff that are present? And you do have those written reports in front of you. Yes, I've got some of them handing out. Okay. Any questions, comments about the reports? Being none, then we'll move on down to Mr. Baker. Did you have an amendment?
Yes, if I could at this time. I've been asked to amend the agenda to move items 18 and 19 of new business to this point in time. There are grant applications, and rather than have staff stay for the better part of 2 hours and to wait on these, I move 18 and 19 to the head of the list.
Second.
Moved and seconded. Any discussion on this amendment? All in favor, aye?
Aye.
All opposed, same sign. Okay. Items 18 and 19 are grant applications. The first one is the Healing to Wellness Court. It's a resolution authorizing the submission of a grant to the Department of Justice.
So moved.
Second.
Moved and seconded. In discussion. All in favor, aye?
Aye.
All opposed, same sign. Item 19 is a resolution authorizing submission of juvenile accountability discretionary grant application. Do I have a motion?
So moved.
Moved and seconded. All in favor, aye?
Aye.
All opposed, same sign. Okay, moving on down to old business. First item is the Violent Crime Control Law Enforcement Act of '94. That's the one we've tabled several times, including 3 items of concern, and those are the death penalty, juveniles being tried as adults, and there's another one too. Yes, Mr. Baker?
Madam Chairman, at this time I move that we do not pass this.
Second.
Moved and seconded. Any discussion? Any discussion? Item 1. All in favor, aye?
Aye.
All opposed, same sign. Okay, thank you, Mr. Baker. Item 2 is an act relating to elections, amending the provisions concerning staggered terms. Mr. Hembry?
Yes.
You have a proposed amendment here versus the one that was in the packet, correct?
Yes, what is in your packet had 15 distinct districts. That was based on the act that was passed by the council. There was a veto. That veto was sustained, so therefore the current law is 9 districts with...
Madam Chair,
Yes.
I thought this was tabled until the declaratory judgment was answered at the last meeting.
I don't recall that. Does anyone else?
I think Don Garvin.
Mr. Garvin?
I made the motion, it was what we did.
Oh, okay.
So it should be taken off.
And that's the same for number 3 too, I believe.
Number, it's on employment of relatives.
That's also in the declaratory judgment.
Mr. Embry?
It's obviously the pleasure of the council. I mean, I did not go over the minutes in detail after it was on the agenda, and that's why I prepared the act as it is. I would point out to the council, though, that this is the January meeting. Whatever you would pass out of the January meeting would go to the February full council meeting. At full council, it will either be passed or not. But being mindful that your election filing is in March, that would be your last opportunity outside of special meeting to pass a staggered term that would allow individuals to know which seats are a 4-year term, a 6-year term, or a 2-year term, or whatever term that you all come up with. Also, I would state to the council that in both my opinion, or not, I don't say my opinion, or the version created by me to go to the district court about staggered terms, and Ms. Hammond's, the Attorney General's version both are in concurrence in that, is that the council is going to have to stagger these terms to be in compliance with the Constitution, which it gave us 1 year to do, and you're going to be within that year. But it's the pleasure of the council. I just wanted to make those facts clear that, we're outside of a special meeting, this is the only time we're going to be able to consider it.
Mr. Baker?
Madam Chairman, at this time, I move that we approve this act as written by Todd, and on the flip of a coin, decide whether seat 1 is 4 or 6 years, and then whatever that becomes, the next one will be the opposite and rotate all the way through 15. That's
Second.
Moved and seconded. Any discussion?
I'm sorry, what was the motion?
Yes, Mr. He made the motion that we declare seat 1 or seat 2 on the flip of a coin, a 4-year or a 6-year term. And his reasoning on 6-year versus 2-year is, go ahead, Mr. Baker.
According to what the court ends up saying, if they say we're in our first term, then obviously the second term would not make a lot of sense being a 2-year term, because 2 years and you're out. So I would think rather than make a 2-year term, we would make the other term a 6-year term. And that way, if in fact we're in our first term, nobody will have to take a 2-year term and out. And that's the reasoning for it. But and like I say, flip the coin. If seat 1 is a 4-year term, then seat 2 will be a 6, seat 3 will be a 4, seat 4 will be a 6, right on through, and have no control over who's what. Just flip the coin and alternate it from that point. And every district, if like 2 in Tulsa County, one of them would be one and one would be the other, simply because of the way they're on this format. Same way in Adair County, same way in Cherokee County, and the single districts would just wherever they come up in the rotation, whether they'd be a 4 or 6. So, but that's the motion.
Mr. Hoskins?
Ms. Todd, our current constitution, does it specify 4-year terms for elected council representatives?
No, pardon me?
Does it specify 4-year terms for elected council representatives?
Yeah, it does. But again, therein lies the rub that you cannot have staggered terms unless you just hold seats vacant, unless you deviate from that year of term. So either you're going to have to increase it or decrease it, depending on the wishes of the council.
Todd, would we be possibly in violation of the Constitution unless we specify this is contingent upon the rulings of the Supreme Court?
Well, everything's contingent upon the rulings
Well,
of
I
the Supreme
understand
Court.
that, but what I'm saying is this act would not take effect unless the ruling of the Supreme Court agreed with this. Because, I don't think it's in the realm of the council and Cherokee Nation to pass an unconstitutional act.
Well, sure, and that question is before the court. Okay.
What I'm saying is, do we need to add some verbiage to this motion to allow for that?
It wouldn't hurt to add that verbiage. I don't think it's necessary, though, because whether you add it or not, it's still going to be contingent upon whatever the court rules.
But at least we would recognize.
You will recognize that it is a pending question.
Good point. Is that all, Mr. Hoskins? Ms. Cowan-Watts?
I'm satisfied, thank you.
Mr. Jack Baker?
Yes, I think that's a fair way to do it. However, I would like to see the flip of the coin occur after the election so that everyone's on the same playing field in running for office. So that no one's running for a 4-year term, someone else running for a 6-year term. Everyone's running for an office for council. And then once they're elected, we flip the coin and decide who gets the 4 and who gets the 6.
Mr. Garvin and Mr. Baker?
I just want to ask Todd about my motion last time to table this until we hear from the court.
It is,
It's still in effect, isn't it?
right now, it's still in effect. If
So what we're doing now is not legal.
the county, the body can do anything really it wants to do, okay?
No, it's been
It
taken.
can reconsider any
It
kind of,
hasn't been done though.
well, I know, that's why you need to take a vote.
That's not what the motion was. though.
Well, you need to, what has to happen here in this instance, to be procedurally correct, is that there needs to be a motion to rise from take from the table, okay, this act, and then consider it. That would be procedurally correct to do. If there's a majority that says take from the table, you do it, but if it's not, it remains on the table.
Okay, thank you for that.
Mr. Baker,
Yes, I'd make a motion to bring this off the table.
do I have a second?
Second.
Moved and seconded, any discussion? Yes.
Is it two-thirds to take something from the table?
Majority.
Thank you.
Any other questions? All in favor to take this from the table, signify by saying aye.
Aye.
All opposed, same sign.
No,
Roll call.
Bill Ingram,
No.
Bill John Baker,
Yes.
Jack Baker,
No.
Audra Connor,
Yes.
Joe Crittenden,
Yes.
Meredith Fraley,
Yes.
Don Garvin,
no,
Chuck Hoskin,
Yes.
Bill Johnson,
no,
Taylor King,
Yes.
John Keener,
yes,
Jackie Bob Martin, Linda O'Leary,
Yes.
Melvina Shophouse,
Yes.
David Thornton, Carol Cowan Watts,
No.
Phyllis Sharkey.
No, Madam Chairman.
10 yea,
Okay, it is taken from the
Yes, ma'am.
table. Yeah, Mr. Baker?
Madam Chairman, I make my motion again to pass this as it is written on the flip of a coin as to whether seat 1 is a 4-year or a 6-year term, and staggering every other number after that. I think it's something we should do now, and I think that people ought to know up front whether they're running for a 4-year or 6-year term. And the folks that are running against you, obviously they could choose which term they were running for, and instead of running and then finding out later. But that's my motion.
Do I have a second?
Second.
Moved and seconded, any discussion? Mr. King and then Mr. Garvin.
Todd, just to understand this, we certainly don't want to do something that is going to be unconstitutional. So I'm going to ask you for your help in constructing a friendly amendment that says, subject to the ruling of our court. If it was not allowed to have 6 years, then we can't do it. But I agree with Councilman Baker that we need to do something and be in line with our new Constitution. Could you help me construct a friendly amendment, please?
Yes, sir. Ms. Hammond, we may include your help on this too. I would say that you would add the language, something to the effect, said amendment shall take place, or shall take effect. On March 1, 2007, provided that the judicial Supreme Court determination is consistent with said act. Right. Said amendment shall take effect on March 1, 2007, which is prior to the filing, provided that Cherokee Nation courts
Supreme Court.
concur, or Cherokee Nation courts do not hold or rule to the contrary. Okay, I agree with that. We've just pinned here, we would say, said amendment shall take effect on March 1, 2007, provided the Cherokee Nation courts do not hold or rule to the contrary.
Well,
The district court, right?
yeah, I mean, we'd have to take courts out and have to say Supreme Court, correct? Because
It has to go through
it
district
could be
court.
overturned.
You say court, I mean,
That's why you're saying courts?
Well, I mean, if it gets,
Supreme Court's fine.
okay.
That's assuming there will be an appeal, which I'm pretty sure. Okay, Supreme Court, we'll say Supreme Court.
Okay, can you read it one more time?
Said amendment shall take effect on March 1, 2007, provided that the Cherokee Nation Supreme Court holds or do not hold or rule to the contrary.
And that's my friendly amendment.
I will accept.
And with that, we would strike the emergency clause. Because we're setting this and take it back.
Yes.
Yes, I do, sir.
Mr. Garvin?
I'm not quite understanding how this is going to work, Bill John. Let's say we flip the coin. I don't know who's going to flip it. Maybe someone will. Comes up heads. Seat A is going to be 6 years. B is 4. Then A is 6, and B is 4. A is 6, B is 4. Then they come to District 4.
Whatever the next, whether it's a 4 or 6, whatever the next.
All down the line.
Yeah.
But if we come up tails, what happens?
It's the opposite.
4 and then
Start
4 and a 6.
Seat B,
If it's tails, I mean, if that's what we say, tails would be a 4-year term for number 1, a 6-year term for number 2.
what?
He's got on here
Seat A and Seat 1 and Seat 2.
seat 1 and T in
Is that
District
A or
1.
B?
Well, we go through District 1. Whatever the coin determined, seat 1 would be either the 4 or 6 year, and seat 2 would be the opposite. And then we go to District 2 the same way, District 3 the same way, and when you get down to Three Rivers, whatever, whether the number 1 was a 4-year term or 6-year term, that's what you would be. Whatever number 1 was, because you'd be the next one in line.
Then when you get to District 5, it switches.
It would flip, that's right. 1 would be the
Later on, it flipped back.
it flipped back after District 9. Yes, well, no, it ends with District 9. No, with Will Rogers, it would flip again, yes, sir.
And you put the at-large at last.
Yes. And 1 would be 1 and 1 would be the other.
Okay. You didn't say who's going to flip the coin, huh?
I would take a friendly amendment since you flipped it.
I got a 2-headed coin.
Just name your point.
That Todd did.
I would like some other party to do it, to be honest with you.
I'm okay with Dawn doing it. I'll put forward that friendly amendment if the body looks at it.
Audra?
My question is, Mr. Baker, you would not waver from doing it right now instead of waiting till after the election results are final, and then determining which person. I'm kind of in agreement here with the other Mr. Baker, and that leaves everyone on a level playing field if you're in the election process, and then once everyone, all the votes are cast and counted and recounted and whatever else we have to do normally, then we see who's got 4 and who's got 6. Are you not open
Well,
all to doing that, or?
of course, the body can do whatever they want. You know, my thinking is that you'd want to know right now what you're running for, and if the court was to rule that 6-year term isn't right, and we have to make the 6-year term a 2-year term. I think people ought to be able to know that you're running for a 2-year term instead of a 4-year term. I just think you need to know what you're running for. I'd want to.
And Mr. Jackie?
As I said earlier, I do agree with the method, but I believe it should be done after the election, and therefore I can't go along with it as it's stated.
Yeah.
Although I do think it's a fair
what I
method.
heard him say.
Mr. Martin?
Madam Chair, I like Mr.
That's what you're talking about, the flip.
Bill,
Yeah.
your comment to clarify your statements about the 2-year.
Well, if the court were to say that you can't have a 6-year term, then obviously the only other way that we could stagger these terms would be for somebody to have a 2-year term.
Okay, stop you right there if you don't mind. The Constitution is very definite that we are elected for a 4-year term. That's why I'm asking the question about the 2-year.
Yeah.
Maybe Mr. Hembry can clarify that.
But the Constitution also says that this council will devise a method, one time, of staggering the terms. That we will devise a method, one time, of staggering terms so that people are coming up every 2 years. And in my mind, the only way to do it is 2 years or 6 years.
Mr. Martin,
I
continue.
haven't relinquished the floor yet, Madam Chair, but my point would be this. If I came up with a 2-year deal and I was elected, I could go to court immediately and challenge the 4-year constitutional right.
I will tell you my personal opinion on it, okay, which is also my legal opinion. That the Constitution sets forth a 4-year term, okay? It also says, as Mr. Baker pointed out, that you must devise a system of staggered terms. I think it is more legally defensible to go in addition to the 4-year term than to go less than the 4-year term.
I agree.
But this body is willing, and in that way, as you're going in, and just to provide against what you just said, I run for office and then all of a sudden I find myself a 2-year term. I think it's also beneficial that the individual who, if I'm a citizen from South Adair County, I got before me a 4- and 6-year term. Maybe I'm only willing to serve 4 years. Maybe I'm old, and maybe I don't want to, work for 6 more years. But you have, that the citizen has the right to say a very clear, not left to any chance that they know when they go and they file for office. There's 2 offices. There's a seat 1 and seat 2. Seat 1 for a 6-year term, seat 2 for a 4-year term. I will make a conscious decision which seat that I want to run for. That's, and I think that opinion is legally defensible, and I think and because of the specific 4-year term of the Constitution says that it would be a good argument could be made that you couldn't go below 4 years. That's my opinion.
Any other, Mr. Anglin?
Thank you, Madam Chair. Okay. Some more clarification we're needing is all this mumble jumble stuff of flipping a coin, 1, 2, 1, 2, 1, 2, and then you get down to 3 rivers, you got 1. Okay. Now I'm smart enough to figure out that whatever's next is going to be seat 1 after 3. But then they was talking a while ago about when you get to 7, you're going to flip back the other way. Are we flipping back to the tails for seat 1?
Well, this is my understanding of the motion, and Mr. Baker obviously would clarify it, is that there's one flip of the coin. And let's say, hypothetically, if it's the will of the body, seat 1 is flips and it becomes a 6-year term. The next one's 4. Next one's 6. Next one's 4. Next one's 6. Next one's 4. The next one's 6. Next one's 4. 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 Next one's 6. There you go.
Does that put it in order?
Huh?
Does that put it in order?
I mean, that's, Three Rivers would then have a 6-year term, and they,
Okay, so when you get to District 5, you've changed. Seat 1 becomes 4. Seat 2 becomes 6.
right, because see, you just follow in order, 6, 4, 6, 4, 6, 4, all the way down. That's my understanding of the motion.
That is the motion.
Is that all, Mr. Anglin?
That's all. Thank you.
Mr. Garvin?
I see where certain ways we'd have only 8 6-year terms. If you started out with 4 instead of the 6. So I definitely think we should have 9 going with 6-year terms.
Could be 4.
Is that right, Todd?
If that hypothetical just occurred, we'd have 1, 2, 3, 4, 5, 6, 7, 8, 9 6-year terms, including the at-larges. Oh, no, yeah, 9 6-year, not 9. Okay.
We'll start with B on a 6-year assembly.
All right. Let's just reverse it. 4, 6, 4, 6, 4, 6. 4, 6, 4, 6, 4, 6, 4, 6, 4, 6, 4. 1, 2, 3, 4, 5, 6, 7, 8. If you start off 4, you only have 8 that are 6 years.
So you got to flip the coin good.
We need to change that definitely.
Well, the change is going to be the flipping the coin.
Right.
That's what I mean. We need to start with the A's, let them be the 6-year people.
Well, at that point, I don't think it's a gerrymander. I mean, I think that's the whole purpose of flip the coin, is nobody is juggling anything, and everybody's being fair. And it could, if the coin flips right, it's just like you want it. If it's wrong, it's the opposite of what you want.
You don't get.
And I don't know what I want, so.
Well, you could run for seat A or seat B. You don't have to. You still have a choice.
Mr. Martin?
Thank you, Madam Chair. Mr. Baker, would you accept a friendly amendment that the first coin toss would be determined seat A or B? Would that make sense?
Okay.
But it changes when you get down to B.
I guess I'm dense.
Well, the reason, go ahead.
The only true way to do it completely arbitrarily is just to say, someone flip the coin. If it comes up heads, seat 1 is a 6-year term. If it comes up tails, seat 1 is a 4-year term. That's the only way to do it completely arbitrarily.
Forget about my friendly amendment.
Okay. All right. Mr. King,
Call for the question.
question's been called. All minds are absolutely clear, I can tell. All right, the motion is, with an amendment to the motion is, this is to take effect on March the 1st, 2007, provided the Supreme Court doesn't hold or rule to the contrary. Mr. King, is that the way you want that?
I believe so.
Right, Todd?
Yes, ma'am.
Okay. All right, this is an act, so we'll do roll call. Yeah, we're voting on the act as amended.
Bill Johnson,
Yes.
Taylor King,
Yes.
Johnny Keener,
Yes.
Jackie Bob Martin,
Yes.
Linda O'Leary,
Yes.
Nevada Shopmouth,
Yes.
David Thornton,
Yes.
Cherokee Watts,
Yes.
Phyllis Sharkey, Bill Anglin,
Yes.
Bill John Baker,
Yes.
Jack Baker,
No.
Audra Connor,
Yes.
Joe Crittenden,
Yes.
Meredith Braley,
Yes.
Don Garvin,
Yes.
Chuck Hopkins.
Yes.
Okay, motion carries. All right, now do we need to flip the
We
coin?
need to flip a coin.
Okay, heads is 6 years for seat one.
I think the friendly amendment was Mr. Garvin to flip the coin, and you can designate heads
Oh, okay.
4 years or heads 6 years. I mean, if you
Destiny's
want
up
to
to
do it.
you.
I have a coin, but I mean, it's, if you so wish to.
Is that the biggest one you got?
I got $50. I'm a poor Adair County boy. I only got $4.
Too
And
big.
it's probably a two-headed quarter, so check it.
Yeah.
Hey, he's changing that double-headed cord, boy.
Shelley's going to get a, excuse me for interrupting, a camera, because this is kind of a historic occasion. We want to record it.
We've got,
It's on video.
Okay,
Can I
great.
practice a little while?
Okay.
Okay, I'm gonna flip it down here.
Okay, it's going to land on the ground.
Heads, six,
Heads is 6.
six.
Okay.
That'd be seat A.
I need another witness.
won't be on the page.
Madam Secretary of State.
Okay,
Is everybody ready?
What is it?
No
The
doubt.
audience ready. Everybody ready. Here we go.
It is heads, which will be the first seat 6
Right.
years.
Good job.
Okay, so therefore, in that accordance, you have this. District 1, seat 1 will be a 6-year term. Seat 2 will be a 4-year term. In District 2, seat 1 will be a 6-year term. Seat 2 will be a 4-year term. District 3, seat 1 will be a 6-year term. Seat 2 will be a 4-year term. District 4 will be a 6-year term.
Hey,
District 5, seat 1 will be a 4-year term, seat 2 will be a 6-year term. District 6, seat 1 will be a 4-year term, seat 2 will be a 6-year term. District 7, seat 1 will be a 4-year term. District 8, seat 1 will be a 6-year term, seat 2 will be a 4-year term. District 9, seat 1 will be a 6-year term. At large, seat 1, a 4-year term. At large, seat 2, a 6-year term. Is this in concurrence with the body?
Yes.
amen.
do we need a motion on that, Todd?
No, you
because
already...
it was carried in the...
It was
Okay.
part of the act. You passed the act, and that's the terms, and provided that the Supreme Court does not rule otherwise, this will be the law of the land.
Thank you very much. Okay, item 3 is an act relating to employment of relatives of elected officials and amending the ethics, Title 28. Who has that one? Melanie? Ken?
Because there are certain issues that are also involved in the declaratory action, we've recommended this be tabled.
Okay.
Second.
Any discussion? We got a motion to table and a second. Any discussion? All in favor, aye? Aye. Opposed, same sign. Okay, item 4 is an act amending the officers and relating to duties of Attorney General. Is that you, Ms. Johnson?
Madam Chair, for clarification, the item that was placed under the Attorney General Act, which was the one that was tabled, there has now since been a revised version, which would in fact be an amendment of this one. So I would recommend that we take up originally start with this, but if Mr. Keene wanted to substitute the version that he has amended, that would be proper at this time.
At this time.
At this
Okay.
time, yeah. That would be number 14. So once you consider this and consider Mr. Keene's amendment, 14 would be...
All right. Mr. Baker?
Madam Chairman, I move that we permanently table this number 4.
Second.
Moved and seconded. All in favor, aye?
Aye.
All opposed, same sign. That was easy. Ms. Johnson? Item 5 amends the Cherokee syllabary
Madam Chairman.
Mr. Baker?
I talked to Gloria Sly yesterday. They're wanting to have a joint meeting with the Eastern Band, and she was wanting to have this table, and they'll bring it back at some later date. So I believe that we table it.
Moved and second. All in favor, aye?
Aye.
All opposed, same sign. Okay, item 6 is a resolution rescinding the council resolution 6306. Mr. Baker.
Madam Chairman, I'd move that we pass this to full council and dispose of it. It's moved, and I think we need to rescind. I'd make that a form of motion.
Moved and seconded, now discussion. Mr. Johnson?
As I interpret this, we're really denying our citizens the right to vote. It says here in that original passage which authorized the vote of the people, or 6306, for a constitutional amendment defining citizenship and defining requirement is hereby rescinded. They can't vote. That's telling us we can't vote. Now, I've been around a long time, and this goes against everything that I stand for. Everything. How many lives have been lost just to get you the right to vote? I mean, from Iwo Jima to Normandy to Korea, Vietnam, I mean, everybody has the right to vote. And we're taking it away. Period. Thank you.
Mr. Baker?
Yeah, Mr. Johnson, the people have brought a petition forward. There has been a special election called. We're not going to vote on this issue twice, and we're not taking anything away from anybody. We're rescinding a resolution for an election that is to take place after this special election. That's all we're doing. They've already got a special election called, and if for some reason it didn't take place, it would come to the next general election. So we're not taking anything away. We're just taking our names off of it, and it's coming from the people, as it probably should have to start with, instead of coming from this body. And we're doing nobody any harm. We're not stopping the election. We're not keeping anybody from voting for anything. It's redundant and doesn't need to be in there.
Mr. Johnson, and then Ms. Calhoun-Watts.
Madam Chair, I would just hate to have this in our archives of the Cherokee Nation that we voted for something like this. It's just something that's ridiculous. And as I said, it goes against everything I've ever stood for. Thank you.
Thank you. Ms. Calhoun-Watts?
Thank you, Madam Speaker. The way I read this resolution is not only could it potentially compromise our Cherokee people's right to vote on this issue, because of the timing, we haven't guaranteed them the right on this. I mean, the election has not occurred yet. So we can wait until after that March 3rd to address the issues of whether or not this is on the ballot. This does not have to be acted upon now. But it goes beyond that. I'm not a lawyer. In fact, you're the only lawyer that sits on this council. So the way I interpret it and read this resolution is it is anti-Indian. It goes against our tribal sovereignty. It breaches all sorts of what I thought we took an oath of office to protect in this tribe. And I cannot support this resolution, not only for the right that it might jeopardize our people's vote on the issue, but because it is ridiculous from what I understand in how we have obtained our sovereignty, fought for our sovereignty, hundreds of years of Indian law, and it flies in the face of Indian country. Thank you, Madam Speaker.
Mr. Baker and then Mr. King.
I move to table until after the special election.
Second.
Move to table. All in favor, aye?
Aye.
All opposed, same sign.
Aye.
Roll call. Table is yes.
Melvina Shop House?
Yes.
Yes.
David Thornton?
No.
Carrie Collins Watts?
Yes.
Phyllis Yargy? Bill England,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Audra Connor,
Yes.
Joe Crittenden,
No.
Meredith Fraley,
Yes.
Don Garvin,
Yes.
Chuck Hoskins,
Yes.
Bill Johnson,
Yes.
Taylor Keane,
No.
John Keener,
No.
Jack Bob Martin,
Yes.
Linda O'Leary,
No.
Tim? Mr. Gordon, did you vote?
10 yea and 6 nay.
Motion carries to table. Okay, next is new business, resolution confirming the appointment of Troy Potee as a justice of the Supreme Court.
Thank you, Madam Chair. The principal chief respectfully withdraws this nomination at this time. Some counselors have approached the chief and requested additional time to consult with their constituents about the nomination, it being a 10-year appointment, and so he respectfully withdraws at this time and will resubmit at a later date.
Thank you.
Thanks.
Okay, item 2 is a resolution confirming nomination of Joaquin Young as to the CNI board.
So moved.
Moved in second. Any discussion on this Young? Mr. Baker?
Madam Chair, I've got a problem with board members that, has looked at, been given fraud documents and has not made any attempt whatsoever to recoup $66,500, and I will not be able to support it at this time.
Mr. King?
Thank you, Madam Chair. I've known Ms. Young all my life. I have a great amount of respect for her. But I take my duties here and confirmations very, very seriously. And in light of a number of events that have happened at CNI, one of which includes the GEG transaction, that perhaps it's time for a change. I think the world miss Young, but I can, in good conscience, has been a former officer of the corporation, look at her background and say that I feel very strongly that she should be on this board. Thank you.
Anyone else? Any other comments? Okay, all in favor of the nomination of Joaquin Young as to the CNI board signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call. Roll call.
Joe Crittenden,
No.
Meredith Fraley,
Yes.
Don Garvin,
Yes.
Chuck Hoskins,
No.
Bill Johnson,
Yes.
Taylor Keane,
No.
John Keener,
No.
Jack Bob Martin,
Yes.
Linda O'Leary,
No.
Melvin Shophouse,
No.
David Thornton,
No.
Carol Count Watts,
Yes.
Billy Shargey, Bill England,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Audra Connor,
Abstain.
Seven yes. 8 nays.
7 yes, 8 no, and 1 abstention. So he doesn't have the majority, right? Okay. Item number 3 is a resolution confirming the nomination of Bill Grass to the CNI board. Yes.
Second.
Moved in second. Any discussion on Mr. Grass? Yes, Mr. Thornton.
I've known Bill Grass a long time. Also within these resolutions is a nomination for Bill Grass as a member of the business board. I truly don't feel that a person can be on a business board which sets up funding for CNE board or CNI board and also serve on another board. That's kind of like making the motion for funding and then approving it too on another board. So I can't vote for him. I could vote for him on one or the other. It doesn't make any difference. But to be sitting on 2 boards, it doesn't look right to me. Thank you.
Madam Chair, may I address that?
Yes.
I just wanted to note that the current statute provides that members that sit on the CNI and CNE boards, that a certain number of those members also sit on the CMB board, and the purpose of that so that the various needs of those corporate entities are carried forward to the CMB board when they develop plans and overall strategy for the company. So that's the way the corporate structure was set up, and that's the capacity that this gentleman would serve in.
Any other?
Madam Chair,
Yes.
if I could
Yes,
address
please.
that, as Melanie said, the Act requires that CMB's board be composed of 2 members from CNE and 2 members from CNI, and then 3 that are sort of independent. They don't serve on any other board. And the reason was so that we would have a global view of all the business entities at that level and be able to understand the needs both at CNI and CNE. And that's the reason for the double nomination.
Mr. Thornton and then Mr. Hoskin. Mr. Hoskin?
I was just going to say, and I remember discussion of this process of having board members there on the field, and having given a lot of thought to it and seeing some things that have transpired. I wish that we could make those positions advisory, at least on one of the boards, rather than voting on both. So I agree with Mr. Thornton. I can't support one person on both of them.
Mr. Thornton?
There's just one other thing I'd like to say. I can't believe that we don't have Cherokee businessmen out here, enough of them that would sit on these boards where we wouldn't have this problem, as far as I'm concerned, it'd be a problem. And that's it.
Mr. Martin?
Thank you, Madam Chair. I've served on the CNI advisory board for at least 6 years. And I watched the board do the work for the Cherokee. I watched this gentleman. He's a brilliant man. He's a Cherokee, and he's a successful businessman. He has proven what he is and what he can be. And to me, these are the type of people that we need on our boards, especially to take care of our Cherokee-owned businesses and whatever. I certainly support this gentleman. I think he's a man that we need. Thank you.
Thank you.
Madam
Any
Chair.
other comment? Mr. Thornton?
Yeah, I've got no comment
Sorry,
for
Melanie.
that comment. And I say again, in Sequoia County, I can go through and name you probably 50 Cherokee businessmen that could serve on one of these boards. And I just can't understand why we want to discredit them like that's what
Melanie?
Madam Chair, I just wanted to clarify that the principal chief doesn't consider it a problem that Mr. Grass is nominated for CNI and CMB. It's rather a statutory construction of the way we set up the corporations that he feels that Mr. Grass is the most qualified to be sitting on CMB and to represent the interests of CNI on that board as well. So that's the reason for the nomination to CMB as well as CNI. Thank you.
Thank you. Any other question? Mr. Martin?
Thank you, Madam Chair. And I agree with Mr. Thornton. There's probably no telling how many dozen people in Adair County that could sit on this board. But the thing about Mr. Grass is that he's a national renowned businessman. He's out in the business world throughout the United States and is well known, well respected. And that's another reason that I support him. Thank you.
Thank you. Any other questions, comments? All in favor of Mr. Grass's nomination to the CNI board, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call. Yes, as you support Mr. Grass.
Jack Baker,
Yes.
Arthur Connor,
Yes.
Joe Crittenden,
No.
Meredith Fraley,
Yes.
Don Garvin,
Yes.
Chuck Hoskin,
No.
Bill Johnson,
Yes.
Taylor Keene,
Yes.
Johnny Keener,
No.
Jeff Bob Martin,
Yes.
Linda O'Leary,
No.
Melvina Shophouse,
No.
David Thornton,
No.
Carol Watts,
Yes.
Phyllis Sharkey, Bill England,
Yes.
Bill John Baker.
No.
9 yea, 7 nay.
9 yea, motion carries. Okay, item 4 is the confirmation of Jim Carson as a member of the CNI board.
So moved.
Melanie?
Second.
Moved and seconded. Any discussion? All in favor, aye? Oh, I'm sorry.
Aye.
Wait, I'm sorry, I didn't see Mr. Keene's hand shoot up.
Thank you, Madam Chair. Again, looking at all these different nominations, I mean, I think everybody on council knows that, you know, these candidates have to be confirmed. And I know that Mr. Carson comes from a respected legacy there in Adair County. The fact that I have to look at is he has been on the board during so many of these fiascos that we've had at CNI, and there's been a number of them, including the GEG. Previous to that was another telecommunications fiasco that kept CNI reeling, and there was one previous that I'm not really that aware of. But at some point, I'm wondering if it's just time for a change. And as Councilman Thornton was saying, there are a lot of good Cherokees out there, and with just such a track record there, I'd like to see a change. Maybe somebody with a broader, you know, federal contracting background. I know he's a respected member of the community over there, but politely have to say I can't support it. Thank you.
Mr. Baker?
Yes, and I have a great deal of respect for Jim, and there's no doubt he's a good man. Obviously is successful, and for generations they've been successful. However, I really don't believe if it was his money or his bank's money that happened like GEG and CNI, that he would be as cavalier and nonchalant about trying to get the money back. And I just absolutely cannot support that. Thank you.
Madam
Any
Chair.
other questions, comments?
Madam Chair, I just wanted to note that the Principal Chief has the highest regard for Mr. Carson. He's been a long-standing board member and a very respected businessman in Adair County. And the Principal Chief does not feel that the board has taken what the recent events at CNI nonchalantly or lightly. We feel that the board has brought people to task. The board has brought accountability to certain individuals for business decisions that have been made, and that the board is taking responsibility for their decisions. And Mr. Carson has served well on that board and served for a long period of time.
Thank you. Mr. Baker?
Is the Secretary of State debating this issue?
No, she just...
Madam Chair, I'm presenting the Principal Chief's nomination and defending that nomination. Thank you.
Any other questions or comments? Mr. Hembry?
I just wanted to clarify one point, you know, to avoid any confusion about, I know there was a comment about, you know, that there are plenty of Cherokees. I just wanted to make on the record that Mr. Carson is a member of the Cherokee Nation.
Yeah.
Okay. Any other questions, comments? All in favor of Mr. Carson's nomination signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call.
Carol Watts,
Yes.
Phyllis Sharkey, Bill England,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Audra Connors,
Yes.
Joe Crittenden,
Yes.
Meredith Fraley,
Yes.
Don Garvin,
Yes.
Chuck Hoskin,
No.
Bill Johnson,
Yes.
Taylor Keene,
No.
John Keener,
No.
Jackie Bob Martin, Linda O'Leary,
No.
Melvina Shophouse,
No.
David Thornton.
No.
9 yea, 7 nay.
Motion carries. Okay, item 5 is the nomination of Dennis Dowell to the CNE board. It says CNB, but she brought us some corrected resolutions.
Move for approval.
Second.
Any discussion? Mr. Thornton?
Is it Cherokee?
Yes.
Dell, yes. In fact, he runs the Native American Economic Development Office in Tulsa.
Madam
Mr.
Chairman,
Baker.
Clarification, I believe he is no longer with them.
Oh, you're right, you're right.
Just, I mean, for everybody to know.
Yep. But Mr. Dell is Cherokee.
Okay, any other discussion on Mr. Dow? Any discussion? All in favor, aye? Aye. All opposed, same sign. Okay, motion carries. Item 6 is confirmation of B.J. Dumond as a member of the C&E Board.
Move for approval. Second.
Moved in second. Any discussion? All in favor, aye? Aye. All opposed, same sign. Item 7 is confirmation of Mr. Grass as a member of the CMB Board.
So moved.
Second.
Moved in second. Any discussion? All in favor? Oh, sorry, Mel.
I was just going to make a comment. I heard Paul Dell that it was said that he was world-renowned, maybe almost a perfect person, but there's only one renowned person. And we all make mistakes. And so, we can't. And I know during our, when we were doing our at-large hearings and things, there was people out there. I was surprised at the business that they have, out there. One man from Florida, another gentleman from somewhere, but they are a lot of people out there, and so I feel like, I'm just going to make that comment.
Any other discussion? Mr. Grass is a member of CMB Board. All in favor, aye?
Aye.
All opposed, same sign.
Aye.
Roll call, please.
Jack Baker,
Yes.
Bill John Baker,
No.
Bill Anglin,
Yes.
Phyllis Yargy, Carol Cowan Watts,
Yes.
David Thornton, Nelvana Shophouse,
Yes.
Linda O'Leary,
No.
Jack Bob Martin, John Keener,
No.
Taylor Keene,
Yes.
Bill Johnson,
Yeah.
Chuck Hoskins, Don Garvin,
Yes.
Meredith Fraley,
Yes.
Joe Crittenden,
Yes.
Arthur Conders.
Yes.
11 yeas, 5 nays.
Motion carries. Item 8 is an act amending the court and procedures relating to court rules and jurisdiction. Mr. Hembry? I think so. He's still going to discuss it then.
I believe Mr. King will have an announcement on this.
Oh, okay. Mr. King?
Madam Chair, I'm going to pull this at this time. I do want to inform the rest of this body what the intent of this is. There's several items with our judiciary that need to be amended, one of which is the rules for all the courts. And the intention is that as legislative body that we not necessarily approve those, but transmit them and in effect codify those rules that they operate under. Beyond that, I believe that an improvement that can be made within our system is that certain items, such as any cases relating to elections and voting, and intra-governmental disputes between the branches of the government, that those types of items be taken directly to the Supreme Court. For example, we right now have a measure going into the district court relating to several of those items that it's all very important to what we're doing, and it has to go through the district court. And those measures should, in my opinion, go directly to the Supreme Court. But that's what the intention is, and we have yet to get it to that level here. So with that, I'm going to go ahead and pull this from the agenda.
Okay. And Mr. Keene and I have discussed this in at the judicial conference. The Supreme Court justices did ask that a work group be composed to take a more comprehensive approach to bringing all of our laws into compliance with the new Constitution. And so we will be forming a work group to do that. And item 9 is an act amending the courts and procedure relating to jurisdiction. Yes.
Good afternoon. This is one of the first 3 acts on the agenda today that are, I think, the last 3 legislative items that we need for child support enforcement. The Child Support Enforcement Office is set to become operational April 1st. This act, we didn't have child support enforcement before, so there's nothing in the jurisdictional statute of the district court to give it jurisdiction over child support enforcement, and that's what this act does. It defines the district court's jurisdiction to hear child support enforcement cases.
Move for the approval.
Second.
Moved and seconded. Any discussion? It is an act, but all in favor, aye.
Aye.
All opposed, same sign, by acclamation. Item 10 is an amendment to the motor vehicle licensing and tax code for the registration of military and college students.
How are you all this afternoon?
Good afternoon.
Basically, what this does is it amends it for our military people who maintain their residency within our 14-county jurisdiction, but they are stationed elsewhere. And the way the law reads, the vehicle is supposed to reside or be housed in the jurisdictional area. And we wanted to add definitions for our military and also for our college students so that they could still be tagged because they're maintaining their residency here, but the vehicle is being housed somewhere else, not by their own choice particularly.
So moved.
Second.
Moved and seconded. Any discussion? Mr. Garvin.
So if they had a vehicle in our act, they could tag it with the Cherokee tag?
If they took their vehicle over there, if they
No,
still
they bought-
maintained their
they bought one
residency
over
here. I don't know, we haven't come up with that situation. The ones that we have had are people that are housed in another state
Thank you, Madam Chair.
and need it here, but they're still maintaining their residency.
Any other discussion? All in favor, aye.
Aye.
All opposed, same sign, by acclamation. Item 11 is an amendment to the code covering crimes and punishment. Mr.
Yeah, and
Osborne.
again, this is number 2. This amends the current contempt statutes. There was some language we borrowed from Oklahoma back in '93, and there were some things left off, some definitions left off. Basically, contempt is going to be the primary enforcement tool for parents who don't pay their child support willfully. And this just defines the contempts, what they are, and how they can be punished, and how the person who is being punished can purge that
Move for the
punishment.
approval.
Moved and seconded. Any discussion? All in favor, aye.
Aye.
All opposed, same sign. Acclamation. Item 12 is an amendment to the code under civil procedure, adding garnishment.
We do not have a garnishment code right now. This will apply to any judgment granted by our court, but basically I drafted it so that if somebody has a back due child support, it turns into a judgment and gives the custodial parent a mechanism to go and collect what's owed to the children.
Move for approval. Second.
Moved and seconded. Any discussion? All in favor, aye.
Aye.
All opposed, same sign. Acclamation. Number 13 is an act amending the Title 51 of covering officers and duties relating to the office of the marshal. Melanie?
Thank you, Madam Chair. This act we've been working on for several months pursuant to the new Constitution. We think it's nearly in final form, but we'd still like some additional time to refine it some more, so we'd like to recommend tabling it today and considering it next month.
Mr. Garvin?
Move to table this.
Second.
Moved and seconded to table. All in favor, aye.
Aye.
All opposed, same sign. Item 14 is amendment relating to the duties of Attorney General. Mr.
I think this one needs more work too, and I'll move for...
This is one that's yours,
Second.
right, Mr. King? Okay, this has been a motion to table. Any discussion? All in favor, aye.
Aye.
All opposed, same sign.
Aye.
Poor Mr. King. Okay, number 15 is the Administrative Procedures Act. John, are you doing that one? Afternoon.
Good afternoon. We put this together mainly for the Environmental Protection Commission so they can enforce environmental protection rules a little bit better. It also applies to the other 3 commissions, the election, gaming, and tax. All 4 of these commissions have considered it in their meetings and have approved the language here. Something to consider, that it does only apply to those 4 commissions that deal with the public. There are a lot of other tribal agencies that aren't boards and commissions that also deal with the public, that in the future we might consider whether to bring more activities of Cherokee Nation where they deal with our citizens under this act, so that if whatever employees do wrong to a citizen or fail to provide a service or provide whatever they're supposed to provide, the provisions we do for the citizens, that citizen can go to court to get redress. Right now, this only allows people that deal with the tax commission, say the tax commission revokes the license improperly, and they can go to court and get that fixed. But if they refuse to put in a water line for somebody or a septic tank that they might otherwise be due, that person wouldn't have redress to the court. So that's something that in the future we can consider, other departments that might should be considered by this.
Todd, did you have a comment?
There's just, and I reviewed the act, a couple of questions that I would have. First, if I may, Madam Chairman.
Yes, please.
Section 306, emergency rule. It states in section B, it says an emergency rule may be effective no longer than the threat or actual existence of a commercial issue or imminent peril requiring the rule. Let me explain what an emergency rule is. If the principal chief finds that an urgent commercial issue or imminent peril to the public health, safety, and welfare requires an immediate adoption of a rule and states in writing its reasons for that finding, the agency, without prior notice or hearing, or upon any abbreviated notice in hearing that it finds practical, may adopt the emergency rule. And then B, an emergency rule may be effective no longer than the threat of or actual existence of the commercial issue or imminent peril ruling requiring the rule. I guess my question is, do you think it's a good idea to have it open-ended like that, or would it be more prudent to have that the emergency rule cannot be effective for any number of days?
And this has been carefully considered. That if an emergency rule is continued longer than the threat exists, a person could bring an emergency action in court, and a judge can decide, ask the agency, does the threat still exist, and why is this rule ongoing? But to put a 30 or 90 days, this is to cover things that we can't comprehend right now that'll pop up before we could have a council meeting, before they could get a commission meeting together. And particularly with the emergency management crews, the Environmental Protection Commission may have to put in place some rules. They don't know in storms or health outbreaks or whatnot. It's hard to say whether they'll get it resolved in 30 or 60 or 90 days. Presumably in 90 days they'll be able to have a regular board meeting and deal with it, and either make it a permanent rule or dispense with it at a regular board meeting in not too long a time. But and also, like I say, when you come to the enforcement section, if a citizen or whoever feels like the rule's being dragged out longer than it needs to be, they can go to court and the judge can look to
Mr. Baker.
Madam Chairman, I move to table to give Todd a little bit more time to help me understand what would actually be fair on this deal. Second.
Moved and seconded to table. All in favor, aye.
Aye.
All opposed, same sign. Okay. Item 16 is a resolution authorizing a limited waiver of sovereign immunity on Will Rogers Downs, CNE, CNB, and the Cherokee Nation.
Move for approval.
Second.
Moved and seconded. Any discussion? Mr. Baker.
What's the purpose on this one?
The purpose of this resolution is to add CNB LLC to the waiver as the parent company. It changes CNE's legal name to CNE LLC, and it makes the racing license more consistent with the gaming license. It's basically the same waiver that is already in place with the addition of CNB.
Call for question.
Question's been called. All in favor, aye.
Aye.
All opposed, same sign.
Aye.
Roll call. I don't know who said no.
Taylor Key,
Yes.
Johnny Keener,
Yes.
Jackie Bob Martin,
Yes.
Linda O'Leary,
No.
Melvina Shophouse,
No.
David Thornton,
No.
Carol Count Watts,
Yes.
Phyllis Yargy, Joe Anglin,
Yes.
Bill John Baker,
Yes.
Jack Baker,
Yes.
Audra Connor,
Yes.
Joe Crittenden,
Yes.
Meredith Fraley,
Yes.
Don Garvin, Chuck Hopkins, Bill Johnson.
Yes.
13 yea, 3 nay.
Motion carries. Item 17 is a resolution approving the recommendation of Attorney General for payment of attorney fees on the Arkansas Riverbed Settlement Fund.
Thank you, Madam Chair.
Mr. Thornton?
I just had one question. I thought that we paid the attorney fees out of the first payment of the settlement fund.
We did.
I understood that.
We did, sir. We proposed and the council approved a round of payments, and that included a payment to Patton Boggs for $151,000 at that time. Patton Boggs appealed and moved to intervene in the Court of Claims, asserting that they were owed more money under the Arkansas Riverbed Settlement Fund than what we agreed to pay them. That case was won by us, lost by Patton Boggs in the first round of that case. They appealed to the Federal Circuit Court of Appeals, and that appeal still sits there, is my understanding, and we would have to go forward and defend that appeal for them carrying this case forward.
Move for approval, Madam Chair.
Second.
Moved and seconded. Any discussion?
Would you like any more explanation, sir?
please.
Okay.
Sorry about that, Madam Chair.
Rudely interrupted.
That's okay. What has happened since then, since they made the appeal, is that the nation and Patton Boggs have been engaged in some exchange on settlement talks, because it doesn't benefit either of us to keep in court and keep expending money. So we explored whether we could settle. And what has happened is we've made some offers, they made some counter offers, and what it boiled down to is that both parties are agreed to settle for an additional $200,000. So that's what this resolution would approve, would be that settlement amount.
Now, it would cost us, or Diane, approximately how much if we did go to court? Just an estimate.
It could be easily that much if we went all the way through argument through the appellate process, and then of course you could go to the Supreme Court on the certiorari one way or the other after that. I think if we settle for this amount, there's about $500,000, maybe a little over that, still in that escrow fund that then will be released back to us. That money has been held pending this matter in that escrow fund.
Okay, thank you. Mr. Thornton, do you have any more?
No.
Mr. Baker?
In this negotiations and all, and coming to a settlement of amount, did we consider giving them a $100,000 bonus on top of that as well as the other attorneys that represent us?
I think when we talked about settlement, we started from zero. They started from 1.4 million, and we arrived at 200,000. So that's about all I can tell you.
Okay, any other questions, comments?
I have one.
I'm sorry, go ahead.
Patton Boggs came before this body, presented their case, and I felt like they were entitled to more money than what they got, so I'm in support of this settlement. And I don't think Cherokee Nation should get into the habit of sticking anybody on their feet. So I never was comfortable with this, so I support this resolution.
Any other comments, questions?
Call for a question.
All in favor signify by saying aye.
Aye.
All opposed, same sign. Okay, motion carries. We've done 18 and 19. Number 20 is the Donation Act. Todd, do you have that one?
It is, both the next items are for discussion. According to last month, this was before the discussion, and that, we had, in the minutes stated that any additional suggestions would get to me, early January. I haven't received any additional items from the council itself, but what I would ask to do that this be set for the next February rules meeting, and at the end of that time, I will...
Madam Chair, I'd like to table this till February.
Second.
Moved and seconded to table. All in favor, aye. Aye. All opposed, same sign.
In the meantime, I will get with Ms. Knight and any other council members to get a comprehensive donation act.
Thank you. Item 21 is the corporation reform, discussion only. Is that you, Councilor
Yes,
Todd?
last month I handed out a flyer of 11 ideas for the that have been collected by various council members about the possibility of reforming the Corporation Act. That is obviously one of our largest and most detailed acts, and was formulated basically for the majority of it in 1996. Obviously, since then, our corporations have grown, or especially the gaming corporation has grown extensively, and that there may be need, if the council so desire, to put particular amendments in the Corporation Act. These are an ideal starting point, and I would hope that by next month, if there's any additional items that we come with some type of, if it's so desired, of the committee to consider a Corporation Reform Act. So in that mind, within the next 2 to 3 weeks, please give me any ideas or get me to add to the Corporation Act, or get me a statement that, hey, I think that the Corporation Act find a way that, or we know one way or the other where we want to go.
I don't have anything on Corporation Act. I have something I'd like to ask a question.
Okay, so we'll put that on the February rules agenda. And everyone, please submit suggestions, comments to Todd, correct?
Correct.
All right. You need a deadline to get those to you in order to get this composed?
At your earliest convenience.
Okay. All right, thank you, Todd. Now, Mr. Thornton?
Ms. Hammonds? Todd? I've had a couple of phone calls lately, and what they're on is cross-deputizations. And what they're telling me that in this Indian Civil Rights Act of 1968, there's some type of statement in there that says you can't, the only way you can cross-deputize is if it's taken before the vote of the people. And I'd like someone to clarify that. To get somebody to do it, because it,
You want a written opinion on that, Mr. Thornton?
Yes.
Diane, can you get us a written opinion?
And I may clarify with email through Todd or something.
Okay.
Anything else? Our next item is announcements. Do we have any announcements? Entertain a motion to adjourn. Second. All in favor, aye. Aye. All opposed, same sign. Thank you.
Clarify that for me.
Sure.